Versus the state, Manny Arora for appellant, Amy Sopani for appellee.
Mr. Arora?
Yes, if I could save 2 minutes for rebuttal, assuming I can remember to ask for that. Justice Melton, members of the court, my name is Manny Arora, along with Mr. Devin Rafis, who is here anxiously waiting on bar results for Friday, so hopefully he could actually argue with you in the next couple of months. You've all read the briefs, and what I wanted to start with is one of the most difficult things I had to explain to our new potential associate here as to why you're supposed to actually do research and understand the law. If you read the transcript of this case, on both sides of the aisle, it seems like nobody understands the most rudimentary concepts of what the law says, from presumption of innocence, what defensive habitation means, what it means to research the background of critical witnesses. None of that was done or objected to. And the fact that the prosecution made ridiculous arguments about the presumption of innocence, what the instructions for defensive habitation should be, it was just mind-boggling with the experience that these people have. The issue that I'm going to have to wrestle with here is because the trial court gave the correct jury instruction at the end of the trial, even after bad openings, bad closings, and bad questions during the trial itself, is that sufficient to override everything else? And having done scores of trials, just like Justice Boggs, you've presided over many as a Superior Court judge, some of you have litigated these cases, the jurors have been told these wrong things over and over and over again, and never once did anybody object, or did the trial judge sua sponte say, this is just so factually absurd, I need to say something. But instead, it's at the back end of the jury instructions after 45 minutes of sitting there listening to a judge talk and talk and talk at you, and I don't even know how much they're comprehending. I understand the law says a proper jury instruction overrides everything else, but there has to be a reality in order to get a fair trial in this situation. So our brief deals with four specific parts.
Are you asking us to overrule case law on the presumption that jurors follow instructions?
I'm not asking you to do that. I'm just acknowledging that there's realities out there, but I'm also saying there's also practical, common sense stuff that we need to look at. My issue here is simply dealing with the four methods of ineffective assistance of counsel. One, that the sole witness, I know the government in the AG's brief and in the state's brief says there's 3 witnesses that saw this whole incident, and that's not the case when you read the transcript. The defendant's girlfriend was next to him, and she testified that she couldn't see what was going on through the driver's door as to who was punching who or slapping who or any of that. She's out. There was another woman that's the sister of the victim that said she couldn't see anything. So that's witness number 2 that I think has been sort of misrepresented in the briefings. And then you have the victim's brother, who's a 2-time felon currently on probation and had just been released from prison not a few months before this whole thing happened. So you have to ask yourself, if I tell you that the guy that's going to explain facts to you is a multi-convicted felon just got out of prison, inherently every single person would have some bias in their mind as far as assessing that person's credibility, but that never happened here. What the state says is because we were able to impeach him by saying you were somewhat inconsistent in your statements. In the beginning, you told the police that he was punching him, overhand rights and crosses, to eventually at trial it became he just slapped him a few times and they were playing around. That's fine, that was impeached, but you can't minimize the amount of damage a prior conviction or convictions could have done in this case, not just for general impeachment, but for bias and all those types of things, because he is on probation or parole at the time he gave this testimony. The second issue would be the presumption of innocence, where the prosecutor said the presumption can end as soon as the first witness is sworn in and nobody says anything. Just patently absurd as far as that goes, but the defense lawyer didn't know it. The judge didn't say anything about it, and off we go with regards to that throughout the course of the closing statement.
Were there pretrial instructions on the presumption of innocence?
As far as the transcript goes, I don't know if they were done on the pretrial side. I know they were done post, which is what I focused in on based on the way the case law read.
There's normally a set of pretrial instructions, too, that talk about
Yes, Your Honor.
presumption and the burden of proof and all of that.
I don't remember seeing it, but I can't swear to it, but the record is what it is. I focus mostly on the the post-trial instructions. Then we have the issue with the defensive habitation where the prosecutor erroneously, repeatedly said, you need to be carjacked, you need to be this, you need to be that on the defensive habitation. All false, and no objections are made. The defense lawyer doesn't say anything, and the judge doesn't say anything to correct this, and it goes forward.
Did he say that you have to be carjacked, or was he giving something like, say, being carjacked as an example of when you would have a solid defensive habitation?
The prosecutor, she was repeatedly saying that has to be a certain amount of violence or carjacking, examples were used, and that's not the case when it comes to defensive habitation.
But you do have to be, I mean, there is a standard, right?
Yes, the standard is going to be that you can use deadly force for defensive habitation even without fear of great bodily injury. But when the prosecutor...
But you have to have fear of something.
Right, as far as your property being taken from you in a tumultuous or disorderly manner, whatever that may mean to any subjective juror as far as that goes. I'm just talking about the examples that were done to show a pattern of ineffectiveness on essentially both sides talking about wrong factors of the law. So the third thing we would have to then deal with, and Justice Namias, please don't say over and over and over and over again, because I watched that video with regards to the life insurance case you all had a few months ago. The Mallory rule also exists. I understand or is set it aside, and I'd like to discuss that at length, because to me, to some extent, the Mallory rule in this case is a little bit of a red herring to get to the issue that I'm talking about. The point I want to make is the lawyer didn't understand, based on the Court of Appeals ruling as of 2017, that Mallory was still good law until this court specifically says it isn't good law. You guys said that several months after the motion for new trial in this case, the orders came down. So all of that existed, but the defense lawyer didn't know it. In fact, at the motion for new trial, he said, well, I didn't say it because the law was in flux or we weren't sure. Well, I can state my place. That's what I told him. That's usually what lawyers say in these types of situations. And when you go back and you look at Garza with regards to asportation as it comes to kidnapping, the lawyers couldn't know that the law was going to change, so they couldn't object to it. But in this scenario for Mallory, it was still good law at the time because Orr hadn't come down, even though it was in a state of flux. But I understand that's a losing battle for me now, because not only do you all have Orr, but you also have Jackson that came down in June of this year, which basically said we're retroactively saying the 2013 evidence code says that there was no such rule, so there can't be any violation. And that's not an ex post facto. I don't have any issues there because it's not statutory. So the defendant is essentially, pardon my language, screwed as far as that goes, because the rules have changed about his trial after the fact that the trial took place. And that's,
I mean, the fact is, the Mallory rule was deceased at the moment the new evidence code came into effect. We just didn't pronounce the death until Orr.
I agree with you, but the appeals courts along the way had repeatedly said Mallory is the rule of the land until the Georgia Supreme Court says otherwise, and those decisions had come down in 2017.
But as the U.S. Supreme Court said in Lockhart, you can't be deficient. You're entitled to a trial under the right rules.
Yes.
And if it becomes clear later that the right rules were that Mallory is not the law, that's what you're entitled to. You're not entitled to a trial under incorrect legal rules. And the U.S. Supreme Court has held that authoritatively for Sixth Amendment, and we did the same in Jackson.
And so I'm not disagreeing with it. I'm just saying Lockhart Word Fretwell said that back in 1993, and you guys have followed it. I'm just saying, as the role of the defense lawyer, when you look at knowledge, when I'm asking for like a cumulative error issue with all the ineffectiveness that took place, is you didn't even know what the law was. And the Court of Appeals cases as of 2017 had said repeatedly, Mallory is still good until this court says otherwise. And Orr, you said it, so Fretwell kicks in and it's out. So let's look at Orr. What does Orr specifically deal with? Orr dealt with an individual arguing about self-defense where his significant other had attacked him with an ashtray. He didn't call the police or do any of the things. Exact same fact pattern here, except we have a shooting. In that case, you all went through and said, even if the Mallory rule doesn't exist, which obviously it doesn't, multiple prongs have to be met before the evidence is admissible. You said first, there needs to be either an adopted admission, in other words, is it something somebody would respond to, or there's got to be a party's own statement, some nonverbal conduct intended to be an assertion. And you all went on to say, or when you remanded it, said, not telling the police or calling the police or mentioning being hit by the ashtray, that doesn't meet the adoptive admission, and it doesn't mean the party's own statement element as well, which is required under law even without Mallory. And so
what was, in your view, what was the improper evidence produced by the state?
The state repeatedly, from opening the trial and closing, talks about he didn't call the police. He
did call the police, right?
didn't call the police at the time. He called them hours later, and they brought all those types of pieces of information up. He didn't explain what had happened. It was somewhat similar to Orr, and so that's what I want to focus in on and get past the Mallory.
Can we actually focus in on a different issue that I actually think is closer than this one, the defensive habitation issue that you raise? My understanding is you raise it in essentially through the lens of sufficiency.
Yes.
The car that your client was in counts as habitation for purposes of that defense.
Correct.
Our precedent applying the defensive habitation affirmative defense makes clear that you do not have to be in reasonable fear of your life in order to use deadly force.
Correct.
It seems plain that Mr. Ellison entered the car in some form or fashion. So can you walk me through exactly how that sufficiency claim works? Because I do think that may be the closest issue here.
Okay. And the reason I didn't focus in on it is, even though the law was misstated, the jury instruction came out properly at the end of the trial, so maybe I'll focus a little bit more on it. When you start off with what the facts were, from the defendant's point of view as well as the initial witness's point of view, being the victim's brother, there were multiple blows being struck at the individual. And the other thing I want this court to look at and consider is when the girlfriend that was in the passenger seat immediately called the defendant after this, the first thing he said is, I was in fear for my life, whether it's life or not, it doesn't matter because that's not the standard. This is what I did. I thought they were going to pummel me, because you've got a woman that's dating two different guys at the same time with the kids, so there's an inherent issue. They're kicking her out of the house. It's a hostile.
And so, I think that's important, because I think if the argument were that there were no jury instruction, that's at least the slight evidence that would get you the jury instruction, right? So the reason why I think that's important is because when you raise it through a sufficiency lens, there's an interesting interplay there, because you got the jury instruction not just because the trial court got it right in the end, but because there was something from which the trial court should have instructed.
Correct.
Right? And does that then mean that the jury assessed that at least slight evidence and made its own credibility determinations as to each of those pieces of evidence?
Obviously, they made a credibility determination. Whether the former Superior Court judges on this bench can say whether the jury actually understood the rule or not, that's neither here nor there. That's the case law. But what we have here is an improper impeachment of the sole witness. So they're judging essentially his credibility. When you look at the witnesses that were involved in this case, it comes down to him saying they were just playing around, and all the stuff about punching him and giving overhand rights isn't good. So we sort of factor back into, had we looked up his priors, would the prior convictions and the fact that he's on probation or parole at the time this happened.
And when you say improper impeachment, and I'm sorry that I'm not recalling this, is that because they didn't bring out the prior convictions?
Right. The lawyer never even looked it up. His exact quote was, had I known that this guy had prior...
Why isn't that a claim of ineffective assistance of counsel?
It is one of the claims that we've made
But I
here.
thought we were still talking about the sufficiency point.
So on the sufficiency point, this credibility issue relates to the extent to which they were playing around and the extent to which it was a real assault on your client within the vehicle, right?
Correct.
Everybody agrees that there was at least a punch thrown, right?
I don't know if necessarily the jury found that or not, because if you look at it towards the end, it became they were play fighting, which is what the brother ended up saying and one of the other witnesses ended up saying. And so I'm not sure who they're actually believing. And the prior convictions that weren't brought up...
There was physical contact made with your client inside the vehicle.
Yes, sir.
And everybody agrees that regardless of the subjective motivation for making that physical contact, there was physical contact made in the context of an exchange that is not wholly positive.
Correct.
Why isn't that enough for defensive habitation just on its face? I mean, what is the credibility determination that if the jury made an adverse credibility determination against your client defeats defensive habitation?
Well, I just don't think, Justice Peterson, we can look at it in a vacuum saying because contact was made, that's the end-all, be-all. It's like all these other things sort of run together. Did you believe the witness's explanation of what it is? And then is he in fear for some type of disorderly type behavior that you have a right to defend yourself?
Reach into my car and you hit me in the face. I think that's disorderly and tumultuous enough under the case law, right?
I would agree, but nobody moved for a directed verdict, and clearly the jury convicted him. So to me, I have a hard time looking at it just in a vacuum without going down the process of the things that happened and the errors that took place, which then lead the jury to believe that perhaps he didn't have a fear, even if the guy reached in. Just reaching in by itself.
So what is the fear that he had to have?
He
in
had
order
to
qualify?
have a fear of some amount of violence or disorderly behavior with regards to his habitation. It doesn't have to be life-threatening, but it has to have some amount of fear. So if the jury believes that no...
So does it matter whether he was hit with a closed fist or an open hand?
It's a subjective issue, but the concern is going to be when the state walked all of the factors back through the witness to say it was really nothing and the defendant overreacted. Because he was convicted, clearly they believed he would have overreacted and just reaching in by itself or slapping him wasn't enough.
Because even if you enter in a violent and tumultuous manner for an assault, the force has to be what's necessary to prevent the assault. So the jury could decide, somebody reaching in to slap you in the face or punch you, it is not a necessary response to shoot them and kill them.
Correct, and that's why I'm sort of feeding into the whole research that the lawyer should have done to discredit the sole eyewitness in this case, and it's all hand in glove. You can't ignore it.
Well, and I think that was what my line of questioning was before, which is, is the answer on the sufficiency point that really sufficiency is not the right way to get to this claim?
Right. It is enough on sufficiency on its own if we look at it just from a pure legal perspective, like we're talking here, law school, it's an offensive touching or whatever you want to call it. But the reality is the jury voted against us. And so you have to look at what happened along the way to discredit the whole defense of the defensive habitation.
So why wasn't the impeachment that was done enough for us to find that whether or not there was deficiency, there was no prejudice?
As I said in the beginning, Justice Peterson, if I start the conversation off by saying this guy that's about to talk to you is a multi-time offender, currently on parole or probation, there's an inherent skepticism that comes into your mind right off the bat. And the fact that the lawyer didn't do it and the state is brass enough to say, well, that's a tactical decision, which is just idiotic because the case law says if you don't even know about it, you can't make any tactical decisions.
Remind me of the relationship that witness had to your client.
Sole eyewitness was the brother of the deceased, had no relationship to the client.
So the jury knew he was the victim's brother and he had made inconsistent statements.
Correct.
And you think it would make a difference if they also knew that he had been convicted of a felony?
Absolutely, and that's why the statutes allow for those types of things, because it does. I just ask you all to you're not the jury, so I'm not saying put yourself in those shoes, but if I tell you this guy's got X, Y, and Z, you're going to look at it from more of a prism and try to figure out why did his testimony suddenly change to be so favorable to the state. And before
And being the victim's brother is not enough?
No, because he's as good as the driven snow. What's his motive to lie? What's his motive to do anything?
Because his brother's dead.
Because his brother's dead.
Yeah.
Story changed.
Story changed, but that's fine. But if we say that prior convictions aren't enough for a lawyer to know to look for, then we're setting a really bad precedent for...
Well, no, it may be deficient not to do that, but we also have to find prejudice in order to rule for you. And I know you're trying to save your time.
And that's fine. And the other thing I want to say, just on OR, is even if you disagree with me on everything, I think this has to be remanded back to look at the OR factors as to whether these actions are adoptive admissions or the party's own statement, which were very similar to OR. You kicked it back for that. And I think you can easily say that based on him not calling the police and the prejudice that came from it to show that you're not afraid, which is what the government argued, that's why you ran away, didn't call the police right away or call EMS, anything. It all feeds into it. So I'll just reserve the minute and a half. Thank you.
Thank you, Mr. Arora.
Mr. Chief Justice, and may it please the court, my name is Amy Sabani, and I'm here on behalf of the state of Georgia, the appellee in this case. We respectfully request that this court affirm appellant's conviction and sentence for malice murder. I'll go ahead and start with the defensive habitation issue. I think the key fact that appellant is ignoring, and that wasn't really brought out during his argument, is that we have 3 gunshots. We have one gunshot, and then a pause, and then 2 back-to-back gunshots. That first gunshot, I believe, was probably the evidence that was based on the, obviously there was an altercation between the victim and the appellant. And I believe that the fact of that first gunshot, if that was the only gunshot, I think there would really be a sufficiency issue here. However, we have 2 more gunshots, and those 2 gunshots were preceded by a pause. And regardless of whether or not the brother has been impeached by his prior convictions or not, we do have the 3 witnesses. We have the woman in the car, we have the brother, and then we also have the girlfriend who is also out on the street. All 3 of those witnesses were consistent as to the fact that there was a gunshot, then the victim either fell back or he raised his hands, but it seems like they were all consistent on the fact that he went away from the car.
So let me ask you this question. Let's say let's say there's slight evidence of defensive habitation. But you have a situation where someone is defending their home or their car, whatever else qualifies, in a situation that's a close call. But you do have additional force. What do you do with the additional force? Does that always negate a close call?
I think it does in this case, especially when you look at what the extent of the force was. It was a gunshot to the head.
I guess my question is, why is it and how do we know? Because if the first shot is truly to defend, and then you just keep going, and that's not necessary. A reasonable juror could say that wasn't necessary. Is there an excessive force component to the defensive habitation analysis?
I think there can be in certain cases, and I think that here this court is focused specifically on the timing as to when the gunshot was, and there's several cases that talk about how the timing is crucial. So again, after that first shot, again, that one's justified, but after that, those additional shots, the timing is not there anymore.
What is the extent of the pause between the shots?
It's unclear from the testimony. Looking at it most favorably to us, I would say at the least a few seconds, but it does appear that there was enough time for the victim to either hold his hands up or to fall back, because all 3 of the eyewitnesses that we had did kind of agree that the victim had gone back from the car.
My understanding is that the evidence in the record shows that the first shot itself would have been fatal without the 2 additional shots. Is that an accurate understanding, and B, if it is, what relevance do the second and third shots have?
I believe you're correct, Justice Peterson. I believe the medical examiner did testify that all 3 of the shots could have been fatal. I'm unsure of that, but I do think that we do have the kill shot to the head, which would have obviously been fatal regardless of the other 2, and that kill shot did occur after the entry had ceased. So I believe that the jury, as Justice Warren alluded to, I think that they believed at that point that there was no longer any justification. And
so did the medical examiner testify that the victim would have died from the first shot, but did in fact not die from the first shot?
I don't believe that was the testimony. I believe the testimony was any of the 3 shots could have been fatal. Mm-hmm. I don't know if the medical examiner, I don't think this really came out much on direct or cross. I don't think the medical examiner determined, well, this could have been fatal if he hadn't gone to the hospital within 2 hours or anything like that.
It seems, let's say the first shot, inflicted an injury that over a period of hours would have been fatal had it not been treated. But then the second shot, after the entry to the habitation had ceased, was to the head, causing immediate death. Whether the first one or not would eventually have resulted in death is sort of beside the point, because it's not the one that killed him. What I'm trying to understand from the evidence in the record is that parsing possible here? Or is the record simply not precise enough on that point to make those sorts of distinctions?
I think that the record is probably not precise enough. I mean, obviously,
and to what extent does that matter?
I think it can matter in circumstances. I think in certain cases, I do think here we're just looking at the actual assault. We're not looking at all the stuff that happened before and after. We did have the testimony that the victim or the appellant knew that the victim was upset. He had put his gun right there in the cup holder, easily accessible, which was something that he had not done before. So I think we're looking at what had happened before, and that, I think those facts, in addition to the facts that occurred after the fact that he hid the gun, he collected the shell casings, he put his clothes in the dryer. I think that when you look at those surrounding circumstances, I think that changes this case a little bit and makes it different from a case where...
How does that stuff change whether what actually happened at the time was defensive habitation as a matter of law?
Well, I'm not sure as a matter of law, but in terms of, I think the jury consider those things to determine that, and they decided that this would have been a...
Let's say I do something that is absolutely 100% self-defense, but after the fact, because I've harmed another person, I feel bad about it and I take those additional steps. That doesn't disprove self-defense, right?
No, not on its face, but if you add in additional factors, then it could, depending on...
How many witnesses saw what happened in the car before the first shot and testified?
Before the first shot, so the only witness in the car is the girlfriend or the ex-girlfriend of the victim. So she's in the car, so I would actually argue that she probably has the better vantage point.
Does she say what happened during the initial part of the encounter before the shot?
She says that the victim came up to the car and that they might have exchanged greetings or something, and then she says that the victim slapped or hit the, I think she slapped with an open hand, and then she said that she saw the defendant she saw the appellant getting his gun and then firing the shot, then she sees him fall back with his hands up, and then the two additional shots.
And does the brother see that initial encounter, or only what happens after?
The brother does allude to seeing. He doesn't hear the greeting. Obviously, he's not right by the car, but the brother does mention he sees his brother slap him or grab his shirt or something like that along those lines. So he does see that there's something going on between the victim and the appellant, but he obviously has a different perspective than the person who's in the car right beside him. But he did see that there was some activity before the gunshots were fired.
So the jury might consider that initial encounter not sufficient force to justify deadly force in return, but if they did that, they're relying on pretty much the girlfriend, right?
Well, I think they're relying on the brother to some extent too, though he did have some inconsistent testimony as to like the level of hits between.
I mean, the timing issue, when we've looked at timing, we've generally looked at where the victim was at the time the first shots were fired. It's very hard to parse in a self-defense or defensive habitation case a series of shots, that happen. If you're allowed to shoot somebody in self-defense, you're allowed to shoot him in self-defense, and the fact that the first shot knocks him back maybe across the threshold of your house. I mean, by your argument, if somebody is breaking in my house with the intent to kill me, and I shoot him once and knock him back outside the door, the first shot's okay, but then if my finger was shooting the second shot before they fell backward, I've now become a murderer.
Well, obviously, the defensive habitation is going to apply both to residences and a vehicle, and I
think the presiding justice's hypothetical was saying, what if you start inside the house and then you fall outside the house? Right?
Which is not that different from what happened here.
Well, the difference here, I would argue, is that the appellant is in a running car, and why did he not just drive away?
Well, the problem, I thought we did not have a duty to retreat in this state, but part of the problem with parsing shots fired in quick succession is it's always been my understanding that when you are privileged to use deadly force to eliminate a threat, you are privileged to continue to use deadly force until the threat is in fact eliminated, and you have had time to reasonably ascertain that the threat is eliminated. the fact that somebody may have taken 2 steps back from their original position does not indicate the elimination of the threat.
Counsel, I'd like to turn your attention, if I could, to the closing argument. Would you agree that the state's description of the presumption of innocence is just wholly wrong?
Yes.
And if that being the case, thank you, why was the failure to object to a wholly wrong description of the presumption of innocence not ineffective?
Well, the court, I don't remember if they pre-traumated the deficient performance, but I believe it essentially assumed deficient performance.
Would you
on
concede that it is deficient performance not to object to a blatant misstatement of the presumption of innocence?
Yes.
Okay.
And especially, I think the specific wording in this case, I would agree, is somewhat egregious,
What
but
precisely was the language that was a misstatement of the presumption?
essentially what she said was that the victim or that the defendant starts with a presumption of innocence, but that does not carry through the entire trial, and it can be removed once the very first witness stands up and says
why
their
is that
first name.
wrong? I mean, the presumption exists until the state overcomes it.
Well, she was
Proof
saying that
beyond a
the state could overcome their proof just by the first witness coming up and saying their name.
I mean, if the first witness presents enough evidence, I mean, some cases you only have one witness.
Wasn't the statement that if the witness just simply said their name?
Yes.
And would there be any crime in Georgia that a person's name would be sufficient, would be sufficient to prove guilt?
No. So it was, they didn't even say anything.
That is the extent of the misstatement, is
Yes.
that one witness could overcome it simply by saying my name is.
Yes. So that was the statement, and obviously that completely flies into the face as to what the presumption of innocence is.
So it is deficient, it is wrong. Why is it not prejudicial?
Because we have the instructions both at the beginning with the pretrial instructions of the jury before the trial began, and then we also have the very lengthy instructions at the end. And again, this court does presume that the juries follow instructions, and the correct instructions about presumption of innocence, the instructions about what's said in opening, closing by lawyers are not evidence.
So as long as jurors are properly instructed as to the standard, prosecutors and attorneys practicing before the courts of Georgia are free to misrepresent, provided the other side doesn't object, the standards.
Well, I disagree with that. Obviously, the court could have stepped in and sua sponte corrected the prosecutor, which they did not do here. And again, I think it does depend on the facts of the case. Obviously, I know there's the Devilbot case where there was a similar.
Well, that was a lot worse. I mean,
that was because of the evidence in that case was pretty flimsy in compared to this case, which I think.
Well,
the evidence was
and
much
here,
better.
just to compare, obviously there was a focus during Mr. Aurora's argument on the closing instruction by the trial judge. There also was a pretrial instruction at pages 352 and 353 of the transcript. And I think the key language is, the presumption of innocence remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the charges made in the indictment. So plainly that instruction is inconsistent with the idea of merely saying a name by a witness is enough.
And in addition, I guess it helps somewhat, but in this county, this happened in this case, they do have the printed out instructions that are sent back with the jury. So if the jury had kind of nodded off during the instructions, they did have that to refresh their recollection.
On the Mallory Orr issue, I mean, it seems like everybody was operating in a Mallory world below. So the issue was argued, and the trial court's order resolves it all kind of on the assumption Mallory is the governing test. What are we to do with that now that we're on appeal? I mean, you're right in your brief to say, well, Mallory's not the governing law. The new rules of evidence are, but as we said in Orr, that creates a whole set of issues about how the new rules of evidence apply to this stuff.
Well, I think I know there was a reference in the trial court's trial court's order, there was a reference to Eller in this case, which this case mentioned that Mallory it was an unsettled question of law as to the applicability of Mallory. So there was that basis. But I think another thing the court focused on, which it didn't have a benefit of for the other two ineffective assistance claims, for this particular ineffective assistance claim, we actually had testimony from the trial counsel about his decision not to object. But in addition to that testimony, we also have the fact that it's very clear just from the reading of the transcript and the cross-examination that he did use this point about the fact that the appellant had not called 911. He did turn it a little bit on his head, and he tried to kind of bring out this idea that the appellant was scared, he didn't know what to do, he was in a state, I know he elicited a lot of testimony from the appellant about how he didn't have any friends, he had moved from another state, he wasn't really sure what was going on, he was disturbed.
So what do you make of Mr. Arora's suggestion that, consistent with what we did in Orr, we ought to remand for the trial court to make sort of the additional determinations that in Orr we said, look, the good thing about Mallory was it was a bright line. We don't have that bright line anymore. We got to make these messy fact-specific determinations in each case. And obviously, because Orr hadn't been decided, the judge didn't make any of those determinations.
Well, I think that, unlike Orr, a remand is unnecessary because we're not dealing with a substantive issue, we're dealing with ineffective assistance. So we can resolve it based on the trial court's finding that the attorney's performance was not, what he had done was not patently unreasonable based on what he had done with the statements and how he had tried to, again, turn that on his head to try to support the self-defense claim. And then also, this can obviously be resolved on prejudice.
I mean, the trial counsel was making those assessments presumably based on his understanding of Mallory and whether or not, instead of doing that, raising objections, would be a good idea. How do you do that? I mean, is your argument that Mallory was always more protective than the new rules of evidence?
I think that Mallory, again, obviously we have not had that many cases come out since Orr, but I think that Mallory this court described it several times as a bright line rule and this court applied it not only in the context of cross-examination and evidence, but also applied it to prosecutor statements and opening and closing. And we have had the Jackson case come out since then, but there's absolutely no guidance as to how this new Orr universe will work with dealing with opening and closing, or mostly focused on evidence 403 issue. But I think that, as you noted in the opinion, that it's required a careful consideration, facts, very, very fact specific. And I do think that there are going to be situations where what was prohibited under Mallory is going to be allowed under Orr. But
so I guess if you're making a strategic decision based on the idea that if I objected, there's a bright line rule that might help me, you would make the same strategic decision if you weren't sure if you objected, if you would even be able to get it excluded.
Well, I think, I really don't think that calculus occurred in this case, but again, I know there are several Mallory cases where you all looked at Mallory and you looked at it under the ineffective assistance, and there are several cases where the court looks to the other strategic determinations that trial counsel made. For example, I believe in the Goodrum case, they talked about, he decided not to object, but instead of objecting, he decided to use those statements in his closing argument to talk about how ridiculous the state's theory of the case was. And I think that somewhat occurred in this case. So whether or not, the issue is not necessarily whether or not the statements were improper, it's whether or not counsel's decision not to object was patently unreasonable. And I think that based on his testimony alone, I think that the court can actually resolve that issue. If the court has no other questions, I will again ask that you affirm the trial court's order denying the motion for new trial and affirm appellant's conviction and sentences. Thank you.
All right, since I only have 90 seconds, first and foremost, I'm going to again ask for the remand because the state in its own brief on page 18 concedes that the activities that we're complaining about under Mallory or post-Mallory or whatever we want to call it don't qualify as adoptive admissions or under the party's own statement, and that has to be decided. And then if that's decided, then you go to the 403 analysis.
But
that
if you
guys-
made a strategic decision that I could get this out under the bright line rule of Mallory, but it's good for my client, or I don't want to object, why would you not make the same strategic decision if you're not sure if you could get it excluded?
Well, Justice Namias, all respect to the trial counsel, that's idiotic. Why would I want the government sold from the opening to the closing saying he wasn't scared, he fled, he didn't do this, he didn't do
That just becomes
that?
a question of whether it's a good strategic decision or not.
He doesn't know the law. You've seen the error after error in this situation, so we can bend over backwards and say he knew what he was doing. That's not the case. With regards to the Supreme Court's own brief that you left out in the public room that talks about this case, the victim was angry at the defendant and his girlfriend because she was dating him. That is already there, and we know that. He shows up to the car, whether he's punching him, slapping him, whatever, it all sort of changes. And every single person here is a competent lawyer, government or defense, would want prior convictions coming in to try to impeach it, because he is what this whole case comes down to, and that wasn't done. Whether the 3 shots were 1 half-second delay, 2 more shots, it doesn't matter. They have witnesses at this trial that said the 3 were shot simultaneously.
Thank you,
Thank
Mr.
you.
Moore. Thank you, counsel, from both sides.